May it please the court, my name is Michael Germain and I represent Fred Pena. Fred Pena is a retired firefighter and was a participant in the Deferred Retirement Option Program, commonly referred to as the DROP.
I saw something that this originally was brought as a class action, but I'm assuming it's never been certified as a class. Is that correct?
Correct, Your Honor.
As a single?
It's still is a purported class action. The class has not been certified.
Okay.
Yet. I believe a motion has been filed, but it was never set for hearing prior to the motion for summary judgment.
Okay, thank you.
Yes, Your Honor. Mr. Pena filed suit against the board who administers the city pension fund. Mr. Pena now appeals the circuit court's grant of summary judgment in favor of the board. This case involves a supplemental benefit program called the 13th Check Program. The DROP and the 13th Check Program are creatures of contract and statute. The pension contract, Section 26 and 27, created the DROP and the 13th Check Program. The way the 13th Check Program works is that the pensioners get monthly retirement distribution benefits throughout the year, and then if certain conditions, three conditions are met, they're measured at the end of the fiscal year, which is the September 3rd.
I assume that there appears to be no dispute that the trustees could have parked that money someplace other than the DROP accounts pending the appeal in the similar case. Am I correct on that?
Well, Your Honor, Mr. Pena does not believe that that is the issue here, and he's not necessarily willing to concede that. I mean, there is some logic to the board parking the 13 check funds that were at issue for they are paid out differently to retirees and to the DROP participants. And so there is some logic, admittedly, to taking those funds, at least as they relate to the...
Your argument is by doing that, they didn't get out of paying the contracted interest return.
Yes, Your Honor.
But I'm trying to understand how to read the provisions. The interest that is earned is on the money that gets deposited into the DROP account. Is that correct?
That is correct, Your Honor.
And this money was parked somewhere else, arguably for a prudent reason, so as not to undo the whole thing if the appellate court ruled adversely in the similar case.
That is correct, Your Honor. However, those monies should have been accruing pursuant to the contract, at least for the DROP participants, the fund's net investment return.
Irrespective of whether or not the funds were actually in a participant's DROP account?
Well, that is actually what the board has admitted in the Parker case, that in that case, the funds were, the board took the position that the funds were not owed. After suit was filed, they basically came to the conclusion that they were owed, and yet, even though they weren't actually accrued into the DROP participants' accounts during that period, the board admitted that, yes, it's the pension contract that specifically mandates that the interest rate to be applied to the DROP participants.
Yeah, but is that a stipulation made in the context of settlement that, you know, here's a term, there's an argument as to what the interest is going to be, and yeah, we're settling the case. We'll make that concession to settle this case.
Well, Your Honor, that's one argument. I mean, and that would certainly go to the judicial estoppel argument, but they did admit specifically that that is the pension contract, and in fact it is, that the pension contract is the only provision anywhere that specifically states for the DROP participants, this is the interest rate that is mandated.
Was there notice given to the people affected that the money was being segregated? Did they know this was occurring, or the board did it and said this is the interest that money earned?
Prior
to the board segregating the money in a separate fund?
That I don't know, Your Honor.
Okay.
It was timely paid. It was put into this separate account in a timely manner.
That I'm not aware of either,
you have to certify the conditions are met in September, then the funds have to be paid by the following June or something like that?
The funds are supposed to be paid by the following June, yes, Your Honor. And in fact, actually in this case, it wasn't until August that the funds or the board's actuary certified that the amounts. So it appears that there was some sort of delay.
Okay.
However, it is very clear that the pension contract is what governs the payments, the distributions, and Section 27 clearly states that the interest rate to be applied is the fund's net investment return. The circuit court held that because, as Your Honor just pointed out, because the funds were not actually accrued into the account, that was they didn't actually earn the net investment rate. But however, again, Parker, the board has admitted to that any delay in the issuance of the 13 check would, the fund's net investment return would apply to the accumulation of interest during that time period. The circuit court also held that the board had discretion to apply a different interest rate. However, the two cases that the circuit court relies on, Shannenberger and Reeds, really are in opposite to the facts here. Basically, it appears the court was just citing those for the proposition that a trustee may exercise discretion in the discharge of its duties, and such discretion is not to be overturned by the court except for an abuse of discretion. However, in those particular cases, in those particular cases, it dealt with whether the contract language actually, or the trust document actually gave the trustee in its sole discretion some power to do something, and then in Shannenberger it was whether they could ask for additional information to make that decision, and the court said yes they could because the trust document didn't set any specific.
But that's really not the issue here. If I'm reading these correctly, I think everybody agrees that wherever that money was parked, whether it was put in the drop account or whether it was put in this other account pending the resolution of the appeal in the similar case, the interest should have accrued at the net investment rate. That's what we're talking about. It's not a question of the discretion to park it someplace.
Correct, Your Honor. That is Pena's position that the central issue in this case, the only issue that he filed suit upon
is the amount of the interest rate.
Right.
That should have accrued on that. Okay.
Right. And so, and the only reason I bring up discretion is because the circuit court judge did find that they had discretion to park it in there and then consequently to apply the other interest rate. However, I would suggest to this court that that the board did not have discretion to apply a different interest rate. One, because the contract language is very specific as to what interest rate is to be applied to drop participants. And secondarily, while it may make some logical sense to park the overall retirees' 13 check funds in a separate interest-bearing account, that same logic does not apply to
So if the investment performance rate in one of the years in question, hypothetically, was 4.1% and not 5.1% that was in the fixed account, where does that difference in money go? Does it still go to the participants?
To the drop participants?
Yeah.
Well, if there was you're understanding that if there was a negative difference?
Yeah, if the money was put in a separate account that earned more interest than what you're claiming is due, because there was 8.5, 23 point something percent, and there's a big discrepancy in interest. But if hypothetically the interest rate had actually been higher in that fixed account,
where would those additional funds go?
I mean, if the performance was only 4%,
right,
rather than 23%, there's a 1% difference. Who gets that 1%?
I would presume that it would go back into the overall fund. However,
but they were only investing the specific funds for specific participants.
Well, they were investing the overall specific 13 check funds, which is just a surplusage in the general fund. So I presume that it would go back into the general fund.
Okay, I mean, it's just a hypothetical.
Yes, Your Honor.
It's almost like you get your cake and eat it too, but you're not taking the argument that it goes somewhere else.
Well, I think the better question, Your Honor, is would they have gotten the 5.11%, or would they have gotten a negative return? And I don't see how they could have not gotten the negative return, because that is what the contract specifically states. And the argument that they would have...
The contract doesn't have a provision that specifically deals with your facts. That if there's a dispute as to money's owed, can the board put money in another account? and take their chances that the rate may be higher or lower than what the performance rate would be?
Well, the contract doesn't specifically address the issue of if there is an appeal in a separate lawsuit.
Well, I'm just saying, you have an unusual set of facts, and that's what this was done.
Yes, Your Honor. It's correct that it's an unusual set of facts that brings the question as to whether the board has discretion to park these funds outside of the fund itself. However, once they do that, the contract is specific as to what interest rate to pay drop participants. And going back to Parker, the board has admitted that when this issue occurs, when there is a delay in the issuance of the 13th check, it is the pension contract that speaks directly to that. That's something that they've actually stipulated to.
Okay.
So they don't have discretion to do that, and they should be judicially stopped from taking an inconsistent position because they took that same position, or they took that former position in Parker, and now they're trying to take a different position in this case. In Blumberg, the Florida Supreme Court articulated that judicial estoppel is an equitable doctrine that prevents litigants from taking inconsistent positions in subsequent legal proceedings. After further research, I do acknowledge that this court has referenced the detrimental reliance factor. That was something that I addressed in my reply brief, that the fourth DCA in Grau had Judge Cope's opinion. It basically said that Blumberg had reshaped the judicial doctrine of judicial estoppel. The second DCA has referenced the detrimental reliance. First of all, I would like to say that I do believe that Mr. Pena was misled and did rely, because he ultimately did file suit not after the joint stipulation in which the board stipulated to these issues that I'm referring to in Parker, but they had already taken that position in their response to the plaintiff's motion for class certification in Parker. And I apologize. If I did not reserve time, I would like to reserve 5 minutes, please.
You want 5 minutes? You're up to 7, so you still got 5 minutes if you want to reserve it.
I'll take 2, Your Honor.
Okay.
Thank you. However, the issue is, I believe it's not necessarily that Blumberg has done away with the detrimental reliance. I think it's more of an issue of these are not elements of a cause of action. But I will say, just going back real quick, that I do believe Mr. Pena relied on that to his detriment because he went ahead and filed suit after they had taken that position. But nonetheless, these aren't really factors. These aren't really elements of a cause of action. They're really factors to be considered in the application of an equitable doctrine. And that is in line with the United States Supreme Court's articulation of the doctrine in New Hampshire versus Maine, which we cite in our brief, which basically says that there really is no way to nail down all of the, in fact, they say probably not reducible to any general formulation of principle. Nevertheless, several factors typically inform the decision whether to apply the doctrine. And then it goes on to list several doctrines, which, by the way, does not include detrimental reliance, but needless to say, it then goes on to say that in enumerating these factors, we do not establish inflexible prerequisites on an exhaustive formula. So I believe that in Blumberg, it's very clear that the Supreme Court is saying that in certain situations like this, where it would be completely unfair for the board to take this inconsistent position, that in fact, it is more of an equitable doctrine to apply, and there doesn't necessarily have to be detrimental reliance, because in Blumberg, the plaintiff had sued the insurance agent subsequently, and there's just no plausible explanation for how they could have been, how that agent could have detrimentally relied on the plaintiff's prior position.
Okay, you got your 5 minutes.
Thank you.
Good morning. Stuart Kaufman on behalf of the Board of Trustees. Judge LaRose, I think you framed the issue correct when you said that the trustees could have parked the money somewhere else, and I don't think that there is a dispute that the trustees could have parked the money somewhere else. Mr. Germain, arguing on summary judgment below, told the court that that's not the issue before the court, and neither is the issue of whether the board properly placed those monies into an interest-bearing account. So,
but why?
And he said that it was logical also to do that. So,
but whether it's put in a separate account or to deal with a pending lawsuit, or whether the trustees say, I just ain't paying the money now, why shouldn't the interest rate accrue? Why shouldn't the interest rate be the net investment rate that's called for in the pension document?
Because those monies are placed in a separate account, they do not accrue into the drop account until such time as they are placed into the drop account. So if you read the contract, the provision, section 26, it says that it accumulates interest.
Whether positive or negative during the drop calculation period, less the cost of administration.
Right, and that's once it is in the drop account. If the monies are not in the drop account, then it does not accrue interest yet.
You think the language is that clear? You think the language is that clear?
I think it's absolutely clear. And if it's not clear, then the board has the discretion to make that interpretation as the administrator of the plan. The contract itself in Section 5, Section 26, and Section 27 give the board the ability to construe the terms of the contract, and that was their construction of the contract. And it is presumed that they do have discretion to do that. And unless that decision is unreasonable or arbitrary and capricious, then that decision stands.
It's sort of like an 11th Circuit ERISA analysis, too.
Sort of. I mean, governmental plans are not.
Right.
You don't have to follow ERISA, but
it is the
yes.
You're saying it'd be the discretion of the board to decide what rate.
If the contract is not entirely clear. I do believe it's clear, but even if there is some ambiguity, the board took the opinion and made the decision that they could place those monies in the separate account, and that the drop account does not accrue interest until the monies are actually in the drop account. They did the prudent thing. They placed it in a separate interest-bearing account. Payments were being made to both drop participants and retirees. So the monies would be directly given to the retirees with no interest if they had not taken the prudent decision to place those monies in the interest-bearing account that accrued that 5%. And he was talking about Parker and why this case is the same as Parker, and I would posit with the court that it is not the same as in Parker, and the Parker case was actually before you in 2012, and you made a decision and you included language in the Parker case that said that the trustees acknowledged that their decision was erroneous, and because to withhold payment of the 13 check, and because they determined that the decision was erroneous, then they settled the case. The trustees in this case do not take the position that their decision was erroneous. They take the position that they properly withheld payment of the 13 check pending the outcome of that maxi appeal. And that's why judicial estoppel would not apply, because there are not two inconsistent statements. It's two separate issues. Also, on the detrimental reliance issue, this court has ruled at least 3 times in the past 2-3 years, post-Blumberg and post-Grau decision of the 4th DCA, that detrimental reliance is ingrained in the concept of judicial estoppel. And Judge LaRose, you wrote the decision in Crawford in which you said that is one of the elements of judicial estoppel. And in those 3 cases particularly, the court found that there was no judicial estoppel because there was no detrimental reliance. The parties did not change their position at all. And there's no change of position or detrimental reliance in this case, as the plaintiffs, well, Mr. Pena and the potential class representatives, were in the drop account. They were considered retired in the drop, did not change their possession, their position at all, and did not detrimentally rely upon any of the actions taken by the Board of Trustees. The court below specifically found that the plaintiff's reliance on the language in Section 26 to conclude that interest earned on drop accounts must be at the fund's net investment performance is misplaced, as no payment or accrual of the 13 check occurred in this case until conclusion of the appeal. In the Maxey case, interest did not start accruing until the funds were placed into the drop account.
Because I'm looking at 26C2, the drop accumulation shall be calculated as follows.
Right, and it says
So
C is interest accumulation as set forth in this section.
Yeah.
And D is the amount of the 13th check pursuant to Section 27.
So C2 presumes that there is an accumulation in a retiree's drop account.
Correct. Once it's in the drop account, it starts accruing interest. So if they're in the drop for a period of 5 years and they get this payment that was being withheld and they still have 3 years left in the drop plan, they would get the interest that the fund actually got for the remaining period of their drop account,
But not
whether
up,
positive or negative,
but not up until then.
but not until such time as it hits the account. They do not vest in that benefit until it is given to them, until it is placed into the drop account. And I think that's the key component here. And we would ask that the court affirm the decision of the trial court granting summary judgment. Thank you.
Thank you.
Unless you have further questions. No, thanks. Have a good day.
Bye-bye. Mr. German, you've got your 5 minutes left.
Yes, Your Honor. Thank you. I would just like to say that as far as in response to whether there was inconsistent positions, there clearly were inconsistent positions in the Parker case. In this case, in Parker, they were saying that the withheld monies, the retirees were paid at the statutory interest rate due to the delay. They were accumulating interest during that time period, and the drop participants were to be paid for that time period on the fund's net investment return. As far as the detrimental reliance issue goes, the cases that the second DCA has referred to this detrimental reliance being an element, or what I consider to be a factor in the application of an equitable doctrine. In none of those cases that were cited in the notice of supplemental authority was the issue of detrimental reliance dispositive. In all those cases, there were other issues that were other factors that clearly were not. For example, in Zachary, the only mention of reliance in that case was in relation to equitable estoppel. In Crawford, there were no inconsistent positions, and the former position was not successfully maintained. So the detrimental reliance, although it was acknowledged, was not really the issue there. In Fintac, there was no inconsistent position taken, as well as in Fleming, there was no inconsistent position taken. I would posit to the court again that in Blumberg, there was no plausible explanation for how the insurance agent could have detrimentally relied on the plaintiff's actions. And so therefore, it's pretty clear that at least the Florida Supreme Court is saying that that is, while a factor, not necessary to have find that judicial estoppel should apply. It applies when there is a mockery of justice, when a litigant is taking two wholly inconsistent positions, which is clearly what the court is taking here. As far as just one last point as it being as far as the segregation of the funds, if the funds have been left in the fund as far as the drop participants, which is what their interest rate would have gone up and down just like they always do. So it doesn't necessarily make logical sense to remove and sequester their particular funds. The point of doing that, I believe, is what the board's position is that was to avoid any sort of market fluctuations that the retirees, the general population retirees, would not necessarily have been affected by. Unless you have any questions, Your Honor. Thank you.
Okay, thank you very much, gentlemen.